Welcome back. We are in court this week. Once again, we start this morning with a home invasion case. It's Monday. This is part two of that same case. The other guy was convicted. He got 20 years. A lot of times, well, almost every time on home invasion burglaries, nobody goes in by themselves. Very few do. So generally speaking, there's more than one co-defendant. When that happens, a judge would have to make a ruling as to whether or not to allow us to try both guys at the same time, which sometimes happens, or especially when there's statements made, one will have to be put off. They'll have to have two separate trials. Anyway, in this case, it was a home invasion up from the Loris area. One co-defendant has gone to trial. The case was severed or split. That guy went to trial. He got 20 years. What we assess is the worst of the two co-defendants will start today, and we'll be able to update you next week on how that trial turned out. So I wanted to talk with you about how different charges come out in our one guy may get 15 years for a certain crime. You look across, another guy gets 16 years, another one gets 10 years, all for distribution second. There's several things that go into that, could go in that. But the most important key to this is that all drug offenses are enhanceable. In other words, if you get a small amount of cocaine in your pocket and they charge you with simple possession, chances are you are going to get a time served sentence, 2 or 3 days in jail, very next to nothing. But as a consequence of that sentence, the next time you're charged with cocaine, whether it's possession or trafficking or possession with intent to distribute, it will be a second offense and then a third offense. So inevitably, that third offense carries huge time. It's like 20 to 40 years. Mandatory minimum 20, mandatory maximum 40 for distribution or possession with intent to distribute, third offense. It would not be uncommon for us to get a person that had 2 priors for possession and now get a distribution, which is actually a sale, or possession with intent to distribute, which is having an amount so large that it looks like you were going to sell it. For us to allow that person to plead as though it was a second offense, that's called a lesser included offense. When the judge hears that case, that judge is now looking at not only what you're pleading to, but what is also your prior record. So even though you're pleading as though it's a second offense, the prosecutor would tell the judge, hey, this is actually his 4th or 5th or 6th or 3rd offense, but we're giving him a break and letting him plead as though it was his second offense. So that may very well influence the judge. The third offense is a huge mandatory minimum, and a lot of times you'll see where people plead as though it's a second offense, and then there's a lot of discretion. It goes from 5 years to 20 years, I believe it is, for distribution second offense. And depending on the prior record will make a big difference in what the judge is going to sentence, especially if it's a prior record for the same type activity. So even though you're reading on the post that it is distribution second offense, it could be a 4th, 5th, or 6th offense. We don't go into all of that, but the judge will know, and the judge will sentence accordingly. Another thing that probably doesn't make as big of a difference is different judges are different people, and it may very well be me and another guy are both charged with distribution third offense, I plead in front of, plead to distribution second offense in front of one judge, and I get 20 years, and another person plea in front of a different judge, and that person may get 10 years. Everybody's different. Every judge's tolerance level is a little bit different. Every case is a little different. So to read it and say, oh my goodness, it is for sure this reason or that reason that this person got 12 years as opposed to 10, we're not doing ourselves any favors by thinking that way. There's a lot that goes in it. There's very little that goes out on a press release. There is, each one of these pleas will take 10 to 15 minutes. Each one, they're represented by a defense attorney that is mitigating on their behalf, and each one there's a prosecutor. So every case is different. You can't really sit on one thing to say, but most of the time it deals heavily with a prior record. There's one other excuse, and this is the least common. Most common is there's been several other drug offenses. They're just pleading to a second. The second we talked about is all judges are different. The third and least common is it would not be unlikely if I've got a person with a little bit of a record or a substantial record, it really doesn't matter, but presently speaking and not included on that record is the fact that a person has shot into several dwellings, been charged with a burglary, pending charges that wouldn't show up on a record. It is not uncommon for us to say we're going to take the drug sentence and bump that up because I can't prove the other ones. That happens. It happens because, especially with gangbangers, victims may not want to come forward. They may be scared or whatever else, and we will add some on the drug penalty because we know we can't do the other ones. That is least common of the three traits, but that happens also. We'll tell the judge and we'll tell the defense attorney, this is why we're doing what we're doing. We're gonna tell them about the fact that a mobile home was shot with 15 bullets through it, and the police arrested this particular person, but the victim will not come forward and will not help. If we've got drug offenses, we may very well add that into the cook. But those are some of the reasons it would be a disservice to each of us and to the people commenting or thinking about it to believe that it's got to be for this reason or that reason. There's a lot. The only way to really know is to come into court and watch it, and we invite everybody to do that. It's all open. There are cameras allowed in the courtroom. You, if you're not working or if you've got time, certainly are welcome to come in. It's not a big secret, but it's also not something that you can post out in a press release. And sometimes, again, it's just judges' feeling on a particular thing. So that's some of the reasons that different people get different sentences.